Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everybody. This is Judge Englander. So this is a petition for interlocutory relief under 231, Section 118. The petition was brought by Walmart. The case is this City of Springfield against Walmart and many other defendants, and the number of this particular appeal is 2020 J0523. And the hearing is on this petition. I have sent out, and I hope both of you got it. Well, first of all, why didn't counsel identify themselves for the record, please?
Your Honor, this is Kate Wallace of Jones Day on behalf of Walmart.
Good afternoon, Ms. Wallace.
Good afternoon.
Ms. Caswan, do you want to identify yourself for the record, please? Patty?
Yes, Your Honor, I'm here.
Ms. Caswan's trying to speak, but we're not hearing her. I don't know what's going on.
Attorney Caswan, if you want to press *6 on your dial keypad, you're on mute.
Folks, thank you for sorting that out. I apologize to everybody for the technological issues, but that comes with the territory these days. Ms. Wallace, this is your petition. I put out there some questions that I need each of you to address during the course of this. But why don't you start? And I'm sure that I'll have questions. And you should start with your first issue, which is the issue of the, as I understand it, the materials that were presented to the DOJ working group, right?
Yes, Your Honor, and thank you for issuing that notice last week. It was much appreciated, and I'm happy to jump in on question number 1 relating to the presentation. Our position is that really the principles and the public policy underlying Rule 408, as well as what the case law calls the investigative privilege or the law enforcement privilege, weigh against disclosure of the presentations here. And in particular, our position is really grounded in the public policy that encourages settlement and the chilling effect that this order will have on private litigants who are pursuing resolution under Rule 408.
Okay,
as
so
well as,
let me interrupt. You'll find that I have a lot of questions. So I understand those 2 points. You mentioned both the principles underlying Rule 408 and the investigative privilege. As I understand it, the investigative privilege is generally a privilege that is accorded to the government, not to a private party. Do you have any cases where the investigative privilege has been accorded to a private party, where the government has not said, we don't want this produced?
Well, I mean, I think 2 points on that. In the MDL, the government did intervene and make an appearance and object to disclosure of materials that were produced, wholesale disclosure of materials that were produced in the MDL. Those objections were recognized by the MDL court and repeatedly have been recognized by the MDL court. So I don't think
this isn't the MDL court. And actually, maybe I need to back up and understand a little bit about that. First of all, who is the government who stepped in and made an objection? Was it somebody representing the same DOJ working group we're talking about here?
Yes, it was an individual who was representing, I believe, the Eastern District of Texas.
Okay. And there is an MDL in the Northern District of Ohio, right?
Correct.
Okay. And what cases are MDL'd in the Northern District of Ohio? Obviously federal cases, but what cases? What in general?
I'm not sure if I can specifically answer that question. What do you mean?
Well, if you're going to cite to me as a basis for me to withhold production here or to overturn a decision ordering production more accurately, something that's happened in the MDL, I need to understand what it is that the MDL even is. I don't know whether their cases are the same, different. I don't know why those cases are in federal court. In this case is in state court. I know nothing about them. So to just say, oh, this happened in the MDL, that's not very helpful.
Sure.
For either side,
sure. No,
by the way.
I appreciate that. So the MDL is a collection of opioid cases that were brought against many of the same defendants that are parties in this case. They relate to specifically activities in Ohio rather than in Massachusetts. And so this, I mean, they're the same sort of general allegations, but different parties are involved.
And they're only cities in Ohio. They're not cities in other parts of the country.
There are bellwethers that are various Ohio counties.
Are there other cases MDL'd from other parts of the country?
I don't believe so.
Okay. All right. So let's come back then to the notion of an investigative privilege. We have somebody in that MDL proceeding from the Eastern District of Texas who said, please don't order the production of what Walmart said to the working group or to the Eastern District of Texas. I'm not even clear on that yet. We don't have that here, right?
We don't have them coming in with reasserting this objection that they've come into the MDL.
And what's been represented to the court, what's been represented to the court is that you folks asked them to do that and that they said they weren't going to take a position one way or the other.
So after we met with Judge Sanders, the plaintiff in this case sent the DOJ our papers relating to this issue, and the DOJ said they weren't going to take a specific position relating to this motion in Massachusetts. They certainly had every opportunity to withdraw their previous objection. They didn't do that.
No, the previous objection wasn't made in this case. It was made in some other case that you're having difficulty even defining to me. Right?
That's true. It was made specifically.
So there's no objection by the government in this case to the production of the documents that are being sought.
That is correct. Okay.
One other question. Apparently there are 3 of these at least in this jurisdiction and all in state court, one against the city of Cambridge, one against the, one brought by the city of Cambridge, one brought by the city of Boston, and then this one. Is that right?
So there are, I believe, 13 or 14 cases pending in Massachusetts, 2 of which have been defined as the bellwethers. One is the city of Springfield and one is the city of Boston. Walmart's not a party in the city of Boston case.
And are all of those, Walmart's not a party in the city of Boston. Okay. Are all of the, that's helpful, thanks. Are all of those cases before Judge Sanders for discovery purposes?
Yes.
So they're all in state court?
Correct.
Okay.
I think the issue, though,
Go ahead.
Sorry, go ahead.
No, go ahead.
I was just going to say, I think the problem, though, is that really regardless of whether or not there's a specific objection from the DOJ in this case, the same principles in public policy that underlie the investigative privilege, that underlie Rule 408, require a consideration of how an order of this magnitude is going to discourage settlement, which is going to discourage individuals from being forthcoming or pursuing and engaging in candid conversations and exploring potential resolution, both between private litigants under Rule 408, but also between 8 entities that are in these discussions with governmental agencies. And so that's the question that wasn't considered
Counsel,
by the
I
trial
understand
court.
your argument, okay? And I understand it probably not as well as you do, but maybe better than some. I understand that but this difficulty has been around for decades. You're engaged in dealing with someone who is on behalf of a corporate defendant with the government who is engaged in investigating whether you should be charged criminally. You need to come in and talk to them about it. When you do that, you potentially expose what you say as not privileged, right? I mean, this is not a new problem, is it?
So we are not asserting that these presentations are covered by the sort of formal attorney-client privilege or work product privilege or any sort of formal privilege that you would have to assert or otherwise would be waived. It really is the public policy and the principles underlying these public policies.
But mass rules, just like the federal rules, say that she, meaning Ms. Kazwan and her client, get any matter that's relevant and not privileged. So don't you need a privilege?
I do not believe you need a privilege. If you look at Rule 408, the cases that are cited in the notes to Rule 408, and specifically the Strauss v. Skernick case, it says, and I'm quoting, "This rule is founded in policy that there may be no discouragement to amicable adjustment of disputes by a fear that if not completed, the party amicably disposed may be injured." That's a case cited in the notes to Rule 408. And while it's not a formal privilege, it truly is the underlying policies that form the basis for the rule.
So what case, I'm sorry, Strauss v. Skernick is the case you just cited, right?
Right, that's in the notes to Rule 408.
And I'm looking very quickly at your table of authorities and I don't see it here. So is this a new case you're citing?
No, we cited in our petition Rule 408 and the notes.
Did you cite Strauss against Skernick?
We did not specifically cite that case, but we did cite the notes.
Give me the full cite to Strauss against Skernick then.
Sure. It's 227 Mass 173, and the relevant page is at 175, and it's a case from 1917.
Well, that was long before the rules of evidence that you're citing. So I guess I'm skeptical that this is a rule that tells me about a privilege one way or another. I'm going to go pull it down if you give me a moment. Okay, the books are right outside. (227) 175.
Well, it's 173, and on the relevant page is 175. I do want to correct the record, though, Your Honor, about the nature of the MDL insofar as that it does include cases from all over the country. The bellwethers that have been defined there involve certain counties in Ohio, but the MDL is national.
Thank you. Yeah, but this is a much more narrow question, right? And also, by the way, it's not discovery, it's evidence. Sure, you can't put in evidence and offer in compromise. The question is, can you get discovery about offers in compromise? And I didn't even see any case law about that. So I'm two layers down from understanding how good your argument is. Number one, I don't really see in your petition enough for me to determine that the documents that you are seeking to protect were actually offers of compromise, okay? And number two, I don't know from your petition what the law is with respect to whether offers of compromise are protected from discovery as opposed from going into evidence. Now, on that latter one, I can tell you my instinct is that a true offer of compromise would be protected from discovery in some other proceeding. That it seems to me is the kind of thing that that you ought to be able to protect, and that there ought to be a privilege around. But I don't know because I don't have the cases on it, and I don't know how to determine whether what you did in the Eastern District of Texas would qualify. Can you help me with that?
Sure. I think some of the other cases that we've cited, we did cite and provide to Your Honor as well as at the trial court level the federal government's position on this, as they stated in the Purdue bankruptcy proceeding. And there are many cases that are cited in that submission that talk about how the better result here is to find that the public policy supports the notion that this type of settlement discussions should not be discoverable. So has been provided in our petition.
But how do I know that it's even a settlement discussion? What was engaged in by you in the Eastern District of Texas?
Sure. So we did say in our to the trial court and the underlying proceedings that these were protected settlement discussions. And beyond that, in terms of creating a factual record, if Your Honor thinks it's appropriate to go back and create that record, maybe that's one path forward. I think the difficulty we have.
You have the burden, I would think, don't you?
Well, I understand
You're
that.
You're asserting a privilege. Didn't you have the burden down there? If you didn't, so you know, another layer to the problems here is this is very unusual, right? To ask an appellate court to get engaged in overturning discovery orders, you know, I'm going to be extremely careful about doing that. Judge Sanders has multiple cases in front of her. She's got a lot of work to do, and she knows a lot more than I do. But it seems to me that this was a burden that you carried down there. And if you didn't carry it, that's a problem for you, isn't it?
So I think a lot of the difficulty here is somewhat to do with the procedural mechanics of how our discovery disputes are set up in the trial court. So what we have is one-page dispute letters that each party submits. And then Judge Sanders has requested, in this case in particular, if she has questions, further briefing on the matter. When she asked for further briefing, it was only with respect to Springfield's request for documents that had been, quote, previously supplied to the Department of Justice. That was it. We then, and so she limited our pages on briefing to 10 pages with the understanding that that was going to be the only issue. We then got a motion to compel that included a lot of different categories that had not been previously discussed. And so we were absolutely hamstrung by the briefing requirements. And I believe in footnote 1, we said if the court has further questions on any of these things, we would need further briefing to address them. So I don't think that it would be a fair result to say that this hadn't been adequately submitted in front of Judge Sanders.
Well,
there are a number of
I'm more concerned with if you want to say, here's some documents we really care about, but I didn't tell the court what was in them enough to reach a conclusion. That strikes me as problematic. What can you share with me about what is in these documents that you are trying to?
Sure. So we're talking about two presentations. With respect to the first question that Your Honor had posed, we're talking about two presentations that Walmart attorneys made to the DOJ working groups. One was in February of 2019. The second was in August of 2019. They are not documents that Walmart maintained in the ordinary course of its business. These are Jones Day created presentations for purposes of going in and talking to the Department of Justice working group. Every single page of those presentations is marked and designated as Rule 408. We went in and we used the presentations and that's it. I'm not sure how much further detail I can get into without disclosing, fully the substance of them. But they were absolutely attorney-created presentations that were made in part for the purpose of going in and exploring the possibility of a resolution between Walmart and the Department of Justice Working Group.
When you say the Department of Justice Working Group, I saw that described in one of the documents here. It's attorneys general from 15 different jurisdictions. Is that right?
That's right. So we are not talking about any of the presentations that Walmart might have made to the Eastern District of Texas. Springfield is not requesting those and has given up any interest in those at this juncture. We're talking about after the Eastern District of Texas declined criminal charges, the investigation then continued with 15 representatives from various states in this DOJ working group. None of those.
Were these thought to be criminal investigations? Were you dealing with the criminal side of these various U.S. attorneys' offices?
The Eastern District of Texas investigation was a criminal investigation. The working group investigation, as it's continuing today, is a civil investigation. And I will point out that none of the representatives in the DOJ working group are from Massachusetts, U.S. Attorney's Office, or frankly, any other district in New England. They don't have a particular focus on Massachusetts. It's not as though any Massachusetts pharmacies or
Have they told you what federal laws they're operating under?
The working group?
Yes.
I'm not aware of that, Your Honor.
So how can, Okay.
I mean, I will say that the public policy that we're talking about here today absolutely encourages the use of these types of presentations to allow the parties to be forthcoming in discussions with the government and possibly explore the possibility of a resolution.
Let me make sure I understand the scope of this problem. There were presentations made to the Eastern District of Texas in connection with a criminal investigation. Those are not being sought. Is that right?
That's correct.
There were two presentations, February and August, that were made to a DOJ working group that was a civil-based group. Is that right?
Correct.
And those are the two that are at issue on problem one that I have here. Okay.
Correct.
I'm going to switch over to Ms. Kazwan for a moment and ask her a few questions. And we may come back or we may go on to the next issue. Give me one moment. Ms. Kazwan.
Yes, Your Honor.
Good afternoon.
Good afternoon.
Your sister says that these two presentations were made to a civil group and that public policy is such that they should be considered privileged because they were related to offers of settlement. What do you say?
No on all counts, Your Honor. First, Your Honor was correct with respect to Rule 408, that is a rule that addresses admissibility at trial, not discovery. And even with respect to admissibility at trial, while the formal offer cannot be admitted for purposes of proving liability, there may be other reasons that the information can be admitted at trial. And so, for example, Your Honor, in the MDL judge in limine motions held that that materials related to settlements or resolutions with the government could be admitted for other purposes, such as knowledge, for Your Honor, or feasibility, or there's various other purposes for which settlement discussions can be admitted. Really,
would you agree that they could redact certain of the information if it had to do with for example, numbers, dollars?
Yes, Your Honor, none of that is an issue in these discussions. Your Honor, when we move to compel, if I could just give you a 5-minute or 2-minute background here, I think it'll be helpful here to you. The MDL has thousands of cases in it. They all involve, it's a mass tort involving the opioid crisis. The Eastern District of Texas criminal investigation involved that same subject matter. So did the 15 working group offices of the U.S. attorneys. There are, in addition to the thousands of cases that are in the MDL, there are actions being brought and investigations by state attorney generals. All of this litigation and all of these investigations involve the same matter.
Whoa, counsel, when you say that to me, my eyes glaze over. The same matter? So they're all civil proceedings that are going on some kind of theory of public nuisance?
While they are, for purposes of the federal claims, they generally involve violations of the Controlled Substances Act.
That sounds different to me than a claim of public nuisance.
Well, Your Honor, yes, it's a different legal claim, but the facts underlying both the violations of the Controlled Substances Act and the claim for public nuisance are very similar.
Why is that?
Because
in what way are they similar?
All of these claims, and they're made against the nationwide manufacturers of opioids, the distributors of opioids, and the chain pharmacies for opioids, all allege two main theories. One, with respect to the manufacturers, that there was a nationwide marketing fraud, and with respect to the distributors and the pharmacies, that they failed to install nationwide internal controls to make sure that the opioids that they were distributing and selling were used only for legitimate purposes. All of these litigations, while you would necessarily have to show damages in your particular jurisdiction, they all emanate from the conduct of central offices of the manufacturers and also the distributors and pharmacies. So what was challenged, even at criminal level, for the Eastern District of Texas, was that the central office of Walmart was in fact discouraging its pharmacists from weeding out illegitimate prescriptions. And the same was true, for example, of the 15 U.S. attorneys' offices, and the same is true of the MDL, and the same is true of Springfield. Where the cases diverge is to the extent that that misconduct, which starts at the central office, in fact, caused the injuries in each of these different jurisdictions. So what you have with respect, for example, in the case in Texas and the 15 U.S. attorneys' offices, is you have basically two types of information. You have the information that addresses the national policies and practices that are directed from the central office, and then you have groups of particular transactions of the particular prescriptions, so that the particular transactions or prescriptions are different from location to location, but the misconduct that is alleged is primarily from the central office, who directs the conduct of the regional and local offices. So so there is necessary and significant overlap with respect to the factual underpinnings of all of these cases, and therefore all of the evidence. So what happened, for example, in the MDL, and what's happening across the country, is that in the MDL, which does involve thousands of cases, there is a discovery order referred to often as a reproduction order, which ordered the defendants
I'm familiar with this problem, counsel. I've got that. That's the next issue. We'll talk about that issue. Right now, we're on privilege, and I appreciate the background. I will tell you that telling me what happened in the MDL is not as helpful as you think it should be.
Okay.
This case is not in the MDL. I don't know the scope of the MDL. I don't know what the claims are. I don't know why those cases are in federal court and this case is in state court. I know none of those things. I assume Judge Sanders does. Maybe she does, maybe she doesn't, and maybe it's important, I don't know. But just saying this is what the MDL did is not the way I can come at this right now. This case is not MDL.
I agree.
I want to jump back to Ms. Wallace for a moment. Can you hear me?
I sure can.
Okay. Isn't Ms. Kazwan right that that some settlement documents are discoverable and even usable in evidence under the way our usual discovery rules work?
I think that that's possible. There are instances where that might be appropriate. I don't think this is one of them. I think all of the cases.
Let me give you a hypothetical, because it sure seems to me that it would be. Suppose your documents talk about subsequent remedial measures. Just picking one out of the air. Suppose your documents say, hey, we changed our practices. We used to do X, now we do Y, and we're much better. Now, as I understand it, and I'm doing this from a long time ago, but some of those things can even get into evidence within the discretion of a judge. And if that's true, why would they be prevented from being produced?
Well, I think under your hypothetical, that might be appropriate. I think our point here is that.
Well, how do we know that that's not what's in your document? In fact, it seems to me that is something that's in your document. I thought that I'd seen a representation to that effect from somebody, that one of the things in what you presented to the U.S. Attorney's Office or the working group was, here's why we've done such a good job of dealing with this. Look at our new program.
I think that might have been plaintiff's reliance on the ProPublica article, which is derived from inappropriately and unethically leaked documents from very dissatisfied DOJ personnel.
None of which is important to me, because all that's important to me is what's in your document, not how they learned it, not whether ProPublica is right, wrong, or indifferent.
Sure. I mean, so our point here, Your Honor, is truly that the principles and the policy that underlies 408 and the investigative privilege and law enforcement privilege, and the Massachusetts cases do call those privileges. I think they're talking about the underlying principles. But the
Mass case that you cite is about a privilege of the government. It's not about a privilege of a private party. It's about,
but I think somebody subpoenaed
the prosecutor to come in and drop off their investigative materials. And they said, no, you can't have that. That's not this case.
And our position is that it's the reasoning, it's the rationale that underlies those policies that disfavor disclosure in this circumstance. We don't want to be in a situation where people are discouraged from either private litigants negotiating with each other to attempt to resolve a matter, or companies who are working with a governmental agency when the governmental agency is investigating them or has questions. It is not what the cases contemplate in any respect. It is a situation where we want to encourage those types of communications. And so our position is that those cases and the principles and policies that underlie those cases very much support the notion that we should not be disclosing this information here.
What is your very best case, 2 cases, 3 cases? What should I go read that's going to tell me, yep, there's a privilege here that Jones Day is properly asserting?
Sure. So the Flatley case that we cited in our briefing, it's 419. Yep. Okay. The Worthington case as well. So both of those
109,
cases.
Is that the 109 Mass case?
Correct.
Okay. What else?
And both of those cases reference it as a privilege. But I do, again, think that they're talking about the underlying principles and rationale relating to the public policy. I would also, with respect to 408, Your Honor, this is a case that was cited in the Purdue bankruptcy, where the federal government submitted its position statement with respect to a request or motion to compel in the Purdue bankruptcy, and it's United States XRL Underwood versus Genentech.
Okay, what's the site there?
It's 2010 Westlaw 8917474.
Is this in your briefs?
It is. It's at Record Appendix Volume 1 at 270.
Is it, again, I don't see it in your, I don't see it.
Sorry, that's not in our brief. That's an attachment. It's in our, it's in our appendix.
2010 Westlaw.
Westlaw 8917474.
And what court was that?
That was the Eastern District of Pennsylvania.
Okay. I'm going to go back to Ms. Kazwan now. Thanks very much, counsel. Ms. Kazwan, isn't she right that there's a public policy concern here?
Your Honor, we don't agree that there is here.
Really? You don't think that that it's appropriate public policy to encourage someone in Walmart's shoes from being as candid as possible with the federal government when faced with a potential criminal indictment?
Your Honor, we just don't think that's what happened here, right?
That's a totally different question. And it's not going to help me to get sidetracked that way.
Well,
I mean, what she's saying is, hey, the federal government came to us. We were at risk of a federal indictment. We had to be as candid as we possibly could be with them, and we shouldn't be left in a situation where we have to worry about that candor because someone is going to piggyback on what we've done with a civil lawsuit. What do you say to that?
Your Honor, that is exactly the argument that's made by the defense bar in connection with not 408, but rather 502A, Federal Rule of Evidence 502A. And there is in the advisory committee notes and in the statement by Congress in connection with that rule, it's set, and the doctrine that you're referring to, that it's referred to as the selective disclosure doctrine. And that doctrine, Your Honor.
I'm listening. Go ahead.
That doctrine was one where the defense bar states that they should be permitted to make disclosures to governmental agencies, including prosecutors, without then waiving any privileges when they are confronted with requests from the private bar for that information. And so that very policy that Your Honor is referring to was considered by Congress and the committee in connection with Federal Rule of Evidence 502A, and it was rejected. But the contrary public policy argument, Your Honor, is the one that focuses on the public interest in knowing what federal agencies and prosecutors are doing. So that, yes, there are public policy issues involved when there are discussions between the subjects of an investigation and the government, but there are also countervailing public policy interests in the public knowing what decisions are being made by the government.
Yeah, that argument's been rejected by the Massachusetts courts, which say flat out that the prosecutor does not have to be committed to giving that information out.
Well, that's right, Your Honor.
And that's also in our, by the way, that's also in the Massachusetts public documents laws, which also protect that information.
Well, Your Honor, that's correct because of concerns that the prosecutor might raise with respect to, for example, disclosing confidential sources, or to the extent that it might harm a witness, or to the extent that the prosecutor's investigative practices might be revealed. But that's not what we're talking about here. What we're talking about
Well, you say that only because you checked with the U.S., with the DOJ on this particular request, and the DOJ did not say don't produce it. That's the only reason you can really say that, right?
That's absolutely right, Your Honor. And if in fact the Department of Justice had come in and raised the investigative privilege, which is a qualified privilege, then the court would look at the particular facts and it would weigh the public's interest versus the government's interest. But that is simply not involved here because Your Honor was correct when we started this discussion. The investigative privilege belongs to the government, not to the subject of the investigation.
What case would you, or two or three cases would you send me to that address this subject of the discoverability in a civil matter of statements made to a prosecuting office? What cases do you rely on?
Your Honor, I think the best case is probably the Pearlstein versus Blackberry case, and it is cited in our two briefs on the motion to compel. That is the case that addresses a situation which comes up, frankly, all the time in the securities fraud area, where the subjects of a securities fraud investigation meets with the SEC or with the federal prosecutors explaining why they should not be prosecuted under Section 10B of the securities laws. And then
where you didn't cite this in your brief either.
Your Honor, they're both, so it's cited in the motion to compel briefs, which are included in the appendix. They're cited both.
What court? Pearlstein v. Blackberry. What court is it?
That's a Southern District U.S. Attorney. It's the U.S. District Court for the Southern District of New York. And there's also the Gruss case, which is also from the Southern District of New York. There are a series of Southern District of New York cases.
Okay. I understand.
Because this comes up often in the securities realm.
Okay. I understand, counsel. Let's switch over now to the second issue, which is what Walmart calls a clone discovery question. And I asked you in my question, how have you shown that all of those documents meet the Rule 26 requirements in this case?
Right. Yes, Your Honor. And well, I think the first issue with respect to that is to look at precisely what it is that Judge Sanders ordered to be produced in Section 1, in item number 1. And what she ordered to be produced was that the documents Walmart earlier produced the U.S. Attorney's Office and the documents that were earlier produced to the working group of U.S. Attorney's offices, quote, apart from those having relevance only to the claims brought in other jurisdictions or grand jury transcripts. So, Your Honor, as I started to explain, there are a group of documents that are relevant to what the central offices do, what the dispensing and distribution policies and practices as directed from the central office are, and those are groups of documents that were delivered to the working group.
Okay,
there was also,
I saw that language and I wondered what it meant because there was no discussion of that language whatsoever before Judge Sanders as I could find.
Well, you're right.
So let me ask the question if I can. So if taking that literally on its face, what has been ordered of Walmart is to produce everything they produce to the DOJ as long as it's relevant to this case.
Well, Your Honor, I would say it slightly differently. Judge Sanders did not want Walmart making those decisions with respect to relevancy itself, right? Where this line is drawn, and it's very easy to see when you see the inventory of documents produced to the working group, which is included, Your Honor, in the September 27th, 2019 letter. The letter, this is a Jones Day letter to the Department of Justice civil area, their consumer protection area. It begins on the RA First Appendix,
so
page
I need to back
170.
you up, counsel. I suspect you know this is coming, but I need to back you up. You started this last discussion with the words, where this line is drawn. How do I know where this line is drawn?
Your Honor, it is pretty clear, I believe, from the inventory of documents.
No, it has to be from an order. This is an order, apparently, that we have. I mean, it's very hard. You guys seem to know what was ordered. Up until this moment, you seem to have agreement on what has been ordered. You wrote your briefs to me as if you had agreement on what was ordered. I read much of the transcript of the hearing. I'm not sure I know exactly what was ordered, and this is in particular the one place where I'm really uncertain what was ordered, because you're right, there is a carve out apart from those having relevance only to the claims brought in other jurisdictions. When you say to me, this is how the line is drawn, it has to be based on something the judge said, doesn't it?
Well, Your Honor, there has been outstanding in the case a reproduction order since June of 2019, right? And so an order that has required the defendants in this case to produce the documents produced to attorney generals across the country, to produce the documents that have been produced to the MDL, that requires that the documents produced in other litigations.
So why do you even need this order then? What's different about this order from the orders that previously exist?
The only difference in this order is it refers to the federal investigation, all right? And so what happened, and Your Honor,
so the
Judge
previous
Sanders,
orders, when you say there were previous orders, they did not have to do with documents produced to the Department of Justice. Is that right?
That's correct.
Okay, so why are those helpful? For all I know, Walmart agreed to those because they weren't concerned about them. But now they say, we don't want to produce in response to this one.
Well, Your Honor, because it established a pattern of productions where the individual transaction documents in other jurisdictions were not produced. So what's happened with respect to the Department of Justice?
That pattern, how did that pattern, I understand now where you're headed. Did that pattern initiate or originate with the court? Was there some kind of order?
Well, Your Honor, that is how the court and the parties have interpreted it for the last couple of years. All right, so in other words, Your Honor, what a large portion of the federal investigation documents are individual prescriptions that were filled in Tennessee. Okay, there's a large portion of individual prescriptions that were filled in the 15 jurisdictions for the U.S. Attorney's Office. That's what I mean by documents having relevance only to the claims brought in other jurisdictions.
All right,
The
let me
rest
stop
of-
you right there. Let me stop you right there. Ms. Wallace, do you agree with her interpretation of the words apart from those having relevance only to the claims brought in other jurisdictions?
I frankly am not sure how to interpret what Ms. Caswan is saying, but I think that's exactly the point. The point is that these clone discovery type requests are not appropriate, because instead what should be happening is they should be asking specific document requests.
You didn't answer my question, and you need to answer my question. This is the problem with taking an appeal from a discovery order, okay? And I understand you tried to get clarity, and you did not get it. I understand that. But I am very hesitant to jump into something that's been going on for years. And so this is where, you know, counsel come to the bar and they have to be candid with the court. Ms. Caswan says, you understand, or you should understand from a history of productions in this case, that apart from those having relevance only to claims brought in other jurisdictions has a particular meaning. And she's suggesting that that meaning is really individual prescription level types of information. Do you agree with her or not?
Oh, I agree with that. I absolutely agree that there are individual states who have requested prescription dispensing data from Walmart.
Do you agree that the language, you agree that the language that is the qualifier with respect to this clone discovery, there's language apart from those having relevance only to claims brought in other jurisdictions. Do you have an understanding of what that means based on the history of productions in this case up till now?
I have to say no, because the problem is with respect to the dispensing data that only applies to other states, I absolutely agree with Ms. Caswan, that would be carved out, 100%. But the problem is there are also custodians who relate to other states that are not from Massachusetts. So maybe there are stores in other states where we've collected ESI, or electronically stored information, and we've reviewed it. I don't know where you draw the line by saying that's only relevant to a claim in another state versus something that perhaps might have some nationwide relevance. And certainly to the extent that it has nationwide relevance, that's going to be something that's already been produced because it was produced in the MDL, which will be reproduced here. But I think just to circle back to what you first said, if we think about the DOJ working group production as a universe of documents, and you said, okay, things that don't relate to other states, meaning only things that are relevant to Massachusetts, that would be an appropriate way to think about this, because then there would be a nexus to those materials to Massachusetts and to the plaintiff's specific claims. And so if we're in a situation where we think about the DOJ production,
don't try to narrow me past what what I personally would be willing to think in that way, because what Ms. Caswan's saying, and it rings true to me, is decisions made by the central office with respect to the way opioids would be distributed out of Walmart stores, out of Walmart pharmacies, decisions about who would be blocked and who wouldn't be blocked made at the corporate level. Those are likely relevant across the board and relevant as well in the Massachusetts case, right?
I agree with that 100%, and they will be produced, notwithstanding the fact that they were produced to the DOJ. Like, we're not withholding documents just because we gave them to the working group. If it's nationwide, it comes from the central office, it's a custodian that we've agreed to, those documents will absolutely be produced in this case. We're not withholding them.
Let me switch to Ms. Caswan for a moment. Ms. Caswan, my difficulty is that I am not comfortable that clone discovery is correct. I am much more inclined toward what Judge Zobel wrote in one of the decisions that you may or may not have seen, called, and this, it strikes me, is really more or less a question of law as opposed to, a question of the discretion of the judge. Darn it. Pardon me, I'm not supposed to say that. I'm having difficulty finding here it is. Are you familiar with a decision she wrote in Capital Ventures against JP Morgan Mortgage Acquisition?
I'm not, Your Honor.
The site is 2014 U.S. District Lexus 51606, and I believe it was cited to me by Jones Day. And in it, Judge Sobel, faced with a similar request for a sort of blanket, what did you give to the government, says, you know, overbroad, not reasonably calculated to lead to relevant information, indiscriminately pursues wholesale production of all testimony materials from all employees. Plaintiff has not demonstrated how this action and other cases investigations into their practices are related or even similar. May vary widely depending on the claims and defenses asserted. Now, you would say to me, no, these are all the same. And I heard you say that. And to some degree, I understand why you say that. But I think, you know, here's another thing she said. Government investigations also may be much broader than the limited subject matter of a lawsuit. You know, unquestionably true, right? So all these things, and she denied, you know, clone discovery as a result. What do you say to that?
Your Honor, what I would say is that that may be true when you're talking about an individual lawsuit, but I think the situation with the MDL and these groups of lawsuit are much more similar to class action discovery, where what you have is that you have named plaintiffs who litigate a case, and that bunch of facts that are developed by the named plaintiffs are applicable to the absentee plaintiffs. And MDL is similar to that, where there is this overlapping body of facts, all right, that is true.
Yeah, but you know, I litigated literally hundreds and hundreds of class actions, sometimes arising from different people against the same defendant and involving the same alleged practices. And I don't recall somebody being ordered, I don't recall us being ordered, just produce everything you produced over there. I recall people going back through the, you know, doing the work the way it's usually done.
Your Honor, I think, and again, I'm going to cite to the same case, this Pearlstein versus Blackberry that I cited to in the Southern District of New York. And whether or not a individual can get discovery from another matter, particularly for something like government presentation, turns upon issues of overlap and also whether or not, as a practical matter, there is a reason to get the information from the government as distinguished from the starting from the beginning in the private litigation. And what's happened in this case, right, and what's happened in the MDL is that, in fact, the disclosures made to the government are more candid. The private party is more forthcoming than has occurred in the private litigation. For example, the person who was the subject of the criminal investigation, whose name shows up throughout the Jones Day letters, Brad Nelson, right, is Jones Day argued initially to the MDL judge that it was not necessary or appropriate to have Brad Nelson be one of the custodians. Then when all of this came out, when these letters became public, right, when the ProPublica articles came out, right, it led the MDL special master to chastise Jones Day counsel for not identifying, for dissuading him from for having Brad Nelson be one of the custodians whose records would be searched. There also were arguments all through the MDL that Jones Day, for purposes of the productions in the MDL, had not been forthcoming with respect to the productions, so that what is being proposed here, which is, well, let's just use custodians and search terms, has been shown not to be adequate to get the same quality of information that was disclosed to the government.
Okay,
So
let me stop you there. Ms. Wallace, is it true that that Jones Day took the position that what's Brad's last name? Nelson, is that right?
Nelson.
Yeah, that he wasn't an appropriate custodian for discovery in this case, in the case in the MDL?
No. Oh, in the MDL, Brad Nelson is on the dispensing side, and at the time when the discussion about Brad Nelson was underway in the MDL, that case was only a distribution case. So there were different claims at issue, and he wasn't relevant. We've agreed in this case that Brad Nelson is a custodian.
What's the difference between distribution and dispensing?
So Walmart distributes opioids, or did, it stopped a few years ago, to itself. But the primary claims in this case relate to the dispensing. So the actual pharmacists sitting at the store who are dispensing the prescriptions.
I understand dispensing is the pharmacist at the store. Who are the distributors? What's the distributorship case?
Well, Walmart was a distributor insofar as that it distributed to its own pharmacies. But I will say that Brad Nelson is a custodian in this case. We've agreed that he will be a custodian in this case. And there have been no claims in this case that Walmart hasn't appropriately designated custodians or otherwise is forthcoming in producing information.
But is it true that that you say, well, those cases were just about dispensing, they weren't about distributing? The cases that were originally filed in the MDL?
Correct. It was a distribution
Distributing
case.
are the people who, or whoever sits between the manufacturer and the pharmacy, right?
Correct. And
Ms.
he
Kaslan, what do you say to that?
Your Honor, the line between distribution and dispensing is not nearly as clear as Ms. Wallace has described. And in fact, the special master who covered all of these claims found that he had been misled, all right, in track 1 by Jones Day on the argument not to have Brad Nelson be one of the custodians. And I would say, Your Honor,
did he literally find that he had been misled? Did he use that word?
He said, I think your conduct was inappropriate. That's what he said.
Used those words. Did he sanction Jones Day?
No, he said, we're going to move on with the new case and Brad Nelson will be a custodian.
Ms. Wallace, is it true that there was a finding that Jones Day's behavior in respect to discovery in the MDL had been inappropriate?
I am not aware of that, Your Honor, but I don't want to represent either way. I was not involved in those discussions, but I have to say that Brad Nelson is a custodian in the MDL. He's a custodian in Massachusetts. We're not hiding anything in this case about Brad Nelson.
If Ms. Kaslan's been fighting this battle,
she's not in the MDL. She is not in the MDL. She's not a party in the MDL. She's not participating in the MDL. So she hasn't been fighting this battle. Just to bring us back, the issue here relates to this clone discovery request. And the case law, you are absolutely right, says that this is completely inappropriate. And the other case I want to point out.
It doesn't actually. Some of it says it's inappropriate, and Judge Sobel said it's inappropriate, and I'm inclined to think that she did so for reasons that are appropriately moored in the federal rules. And at that time, and with her, the federal rules, our rules happen to be the same and generally construed the same. But there are other cases that do allow this clone discovery. I've seen it happen. All right.
I do think the case that's really helpful, though, is the Drake case that we cited to Your Honor, because in that case, it was documents that had been provided to the Department of Justice, and that I think the really relevant language is it says, an order which permits plaintiffs to obtain all the materials furnished in a Department of Justice investigation may result in surrender of documents that are totally irrelevant to the pending litigation. The better approach to discovery here is to require plaintiffs to make individualized demands based upon what may be relevant documents. And that's how we should be proceeding with discovery here. Plaintiffs should serve us with document requests. We can talk about them, and they should be within the relevant geographic scope that Judge Sanders has already determined.
Yeah,
to be
I read
Hampton
Drake
County.
too. I'm more inclined toward Judge Zobel, but in any event, let's move on to the next and last issue, because I know we've been at this for quite a while. The question I had about the last issue, I think I understand the different categories that we're talking about. And as a result, what I understand your argument to be is, as to this category, boy, I'm going to get it wrong, but it's basically, it's those instances in which a particular pharmacist anywhere in the United States has shut down a particular provider anywhere in the United States. B something, BRTF or something like that, right?
Right, their blanket refusal to fill, and
Right.
that's an individual pharmacist decision to refuse to fill all of the relevant prescriptions from a particular provider.
Your objection focuses primarily, maybe exclusively, on being ordered to produce all the BRTFs nationwide. Am I right about that?
Correct.
And your argument is, unless that particular provider provided into Hampden County, there is no reason for us to be disclosing our BRTF on that particular provider.
Correct. If it has no nexus.
And how far
to
back do you want to
Hampden
go? Are you willing to produce every single BRTF that relates to a provider who provided into Hampden County?
Yes. So, and to answer specifically Your Honor's question as to whether or not there was a means short of the ordered production to allow this to happen, the answer is absolutely yes. We've offered it. We're already in the process of preparing that type of production. And with respect to the BRTFs at issue, what we've done is looked at the dispensing data that we've already produced in this case, and run the BRTFs across that dispensing data. And there are 11 prescribed.
How far back in time?
So the dispensing data goes back to 2006. The BRTFs and corporate blocks were really implemented by Walmart in early 2017.
Okay, and you're about to tell me what you found, 11 different BRTFs relating to something?
In Hampden County. So there's 11 prescribers who were subject to a BRTF anywhere in the country, who also had one or more patients fill prescriptions in Hampden County during the relevant time period. So from 2006 to
and you'll provide all
July
that,
2018. Right? Correct.
Have you already provided it?
My understanding is that we are positioned to produce that this week.
Ms. Kazwan, why isn't that sufficient for the Hampden County case?
Because, Your Honor, for one thing, Walmart is not the only defendant in the case. And what Walmart disclosed when they sued the Department of Justice in order to be relieved from the responsibility of recognizing the BRTFs and RTFs was it disclosed that there were nationwide thousands of BRTFs and hundreds of thousands of refusals to fill and hundreds of corporate-wide blocks, right? Whether or not there should have been a corporate-wide block versus a BRTF is relevant to the case as against Walmart. But more importantly, what Walmart presented to the Department of Justice as one of their main arguments as to why it should not be prosecuted was that Walmart said they had in fact changed their procedures, and now, unlike the other chain pharmacies, Walmart could query its systems and identify these wayward prescribers, so that the wayward prescribers nationwide are relevant not only as to Walmart's prescriptions, but also as to Walgreens, to Rite Aid, and CVS, because with respect to the causation arguments that all of the pharmacies are making, they are arguing that you cannot identify a sufficient number of bad prescriptions that were filled in Hampton County.
But is there anything that suggests that what's on Walmart's BRTFs was communicated across to the other entities?
But no, Your Honor, but that's not the issue for relevancy. All right, but there are, as Your Honor knows, to be able to prove this type of claim, all right, you would have to prove that knowledge may be one aspect of whether or not you knew your internal controls were inadequate, but there's also a causation element where the question is, in fact, were bad prescriptions filled in Springfield? No matter how badly somebody might intend their procedures to be, one of the elements of the claim, as everybody has been arguing, the distributors, the manufacturers, and the pharmacies, is that you need to show, all right, that the prescriptions that you permitted to be filled, right, were in fact suspect prescriptions or improper prescriptions, in order to show that you in fact.
I understand the argument. I think I understand it in the same depth that it's being offered. I think I get this one. But here's the problem: if you can't show, and I'm not coming down on this. I'm just saying, if you can't show that Walmart's knowledge was also Rite Aid's knowledge, or CVS's knowledge, or Walgreens' knowledge, you're not going to be able to make the connection you're talking about, right? You just want the opportunity to make the connection.
Well, Your Honor, yes and no. All right, the element for purposes of the adequacy of internal controls and whether or not it was feasible, for example, for Walgreens to have set up the same types of systems that Walmart did, right, would be an element of the case. So if what you're saying is that Walgreens should have had...
But the controls itself, you're going to get all that evidence. You're talking now about the specifics of who was on the BRTF list for a particular, it could be somebody sitting in Idaho who only writes prescriptions in Idaho, right? And you're saying, well, I need to know that for this case because maybe that guy who we thought for Walmart was only prescribing in Idaho, turns out he prescribed in Hampton County for somebody else.
Well, that's what the evidence that we submitted showed, Your Honor. What we showed, right, in order to make this claim, and what we showed to Judge Sanders, is that the investigations by the Eastern District of Texas and the working group showed, for example, that there were prescribers in Florida whose prescriptions were filled in 30 different states. Now, if, for example, to give you the example that Ms. Wallace gave, if there is a pharmacist in Montana, all right, who looks at his patient's prescriptions and says, well, I know my patients, and I know that the following 3 patients are suffering from opioid misuse disorder, all right, and that they have received the prescriptions from this pharmacist, from this, prescriber in Florida, all right, and that prescriber is prescribing throughout Hampden County, but instead of going to Walmart, it goes to Walgreens, then that establishes the causation. And because, Your Honor, you have such a large inventory
No, that
by
doesn't
Walmart.
establish the causation, at least not to me. But I do understand your argument. So let me ask Ms. Wallace. So she says, look, you're a party. Ms. Kazwan is interested in knowing, for purposes of other defendants in the same, similarly situated to Walmart, who's on that list, so she can cross-check it against theirs and see if they were not as good as you at putting them on BRTFs. That's relevant information. You have it. You should produce it. What do you say to that?
I think there's a couple points. One, when you first asked Ms. Kazwan as to whether or not any of the information was shared with the other pharmacies, the answer is no. It absolutely wasn't. And I think we need to think a little bit about what a BRTF is, right? So it's a blanket refusal to fill, and it's an individual pharmacist's decision. So it's not reflective of a company determination as to any particular doctor. And so even different pharmacies can reach different decisions about whether or not it's appropriate to fill a prescription from a certain prescriber. So if a Walmart pharmacist sitting in Idaho,
so they say, look, you had a BRTF on Dr. X. You initiated that in 2018 because of the following behavior. They deposed the person who did it. Then they go over to CVS and they say, Dr. X, prescribed, a whole lot of, you name it, whatever the drug of choice was. And you guys didn't do anything about it. And then they argue to the jury, look, Walmart could figure it out from this particular pattern, but you guys couldn't. Why can't they do that?
Well, under your example, I think at a minimum, there's 2 things they need to do first. One, they need to figure out if the other pharmacy has information as to these prescribers that they're claiming are at issue.
They don't know because they don't know your list of prescribers. You won't give it to them.
No. If that other pharmacy, they're asking Walmart for this information.
They're asking Walmart for the list of prescribers so they can go match it against who prescribed for the other defendants. I think I understand the argument. I think I got
that piece is missing because I think they need to demonstrate that the dispensing actually happened in Massachusetts. Because even under that example, they'd still be getting the prescription that was prescribed in Idaho and given to a patient in Idaho. It doesn't come into Hampden County.
Do you have a way for them to limit that request such that it doesn't capture Idaho to Idaho, but it does capture people who may have written scripts to the other defendants in Massachusetts?
I think it would have to be based on those other defendants' dispensing data, which they're all doing in this case. But I think they also need to go to those other defendants first to see what their own policies and procedures are. But so it's the same thing. So the exercise that Walmart undertook to say that there were only 11, Walmart has thousands of BRTFs nationwide. We've already demonstrated that there's only 11 that relate to patients that had medication, that had prescriptions dispensed in Hampden County.
You don't know how many of them wrote scripts into Hampden County. You only know how many of them wrote scripts to Walmart.
That were filled by a Walmart pharmacy. But I'm saying at the very most, they would be able to say, okay, I'm going to look at CVS's dispensing data, understand who was actually got prescriptions filled in Hampden County, and they can look at those prescriptions and that data that CVS or Walgreens or whatever pharmacy is producing, and they can say, Walmart, we want information about these doctors who dispensed into Hampden County, because it's only those doctors who dispensed into Hampden County that can conceivably.
Well, Your Honor, that it's not even that limited. A very big issue that came up in front of Judge Sanders was that the first party to demand a comprehensive list of the flawed prescribers wasn't even one of the pharmacies, it was the distributors. And that's because the distributors' orders get matched up against the prescriptions that are filled. So that it includes the prescriptions that were filled by Walmart, it includes the prescriptions that were filled by the other chain pharmacies, and it also includes the prescriptions that were filled by independent pharmacies.
Again, I don't think you answered my question, but I don't understand why that's important to the question I asked. Ms. Wallace says you should get the information about particular doctors that you care about because you know that they wrote scripts that were filled by the other defendants, and then ask if those people are on the BRTF list. That's what I understood her to be saying. What do you say?
I was trying to answer that, Your Honor. We are getting from the other chain pharmacies their dispensing data. So it would be, for example, possible to come up with a comprehensive list of every prescriber on a filled prescription in Hampton County. But what we are not getting, right, is we are not getting lists of prescriptions that were filled by non-party pharmacies. However, the distributor defendants, right, filled those pharmacies' orders. So the distributors have argued, right, that in order to show causation as against them, right, you have to show that that other group as well, right, didn't fill bad prescriptions. So that, Your Honor, you would have to get these comprehensive lists from all filled pharmacies, okay, and then back out that comprehensive list of prescribers on everything filled from 2006 to 2019, and then go back to Walmart and ask Walmart to cross-reference that with their...
No, just give a list. You just give them a list and they can check the list. That's all you need to do. You give them a list of who you care about.
But I won't have the list. Well, all right, that's what I'm saying, is that, you know, until we know which prescribers
it can't be that you don't know the list, but somehow Walmart's going to be able to figure it out for you if they're not people that wrote scripts at Walmart. But I understand, I understand your position. You know, the difficulty with it, just from a judge's perspective, is that you're asking for a whole lot of information about doctors that is negative as to those doctors that may have absolutely, in fact, the bulk of this is going to have absolutely nothing to do with the case that you're prosecuting in Hampden County. That's the difficulty I have with it. Okay, I understand though that the defendants are, and perhaps correctly, raising a difficult causation issue for you, and you need to do what you need to do to meet that argument. And I understand that. So I think I've got this one. I think I've got them all. I very much appreciate the argument. I appreciate you taking the time. And I'm taking it under advisement. I'll get an order out as expeditiously as I can.
Thank you, Your Honor.
Your Honor, if I might, I confess I don't know if it's an appropriate question, but we do have, and we had previously moved to stay the underlying court's decision on these topics. We've filed that brief again after Your Honor had denied ours without prejudice to go ask them in the first instance. And so I guess I'll just reassert it orally here.
I appreciate you telling me that, but that court hasn't ruled on it yet, right?
Okay, that's correct. That's correct.
Okay. You can advise me as soon as there is an order from the court. In the meantime, I'm going to be working on this. Okay?
Okay, I appreciate that.
Thank you. Thank you both.
Thank you.
Thank you, Your Honor.